Jonathan, James, how are you doing?
Hi, Ben. Yeah, not bad. All well here, thanks. What about you, James?
Yeah, all well too, thanks. Ben, how about you? How are you and your family?
Yeah, all good here, considering the circumstances. Look, I'm seeing some legal issues float to the surface that are of concern to many in the property world. One major issue at the moment is the effect of COVID-19 on tenants' breaks.
Yeah.
And I thought you both were the perfect persons to chew over some thoughts on this, particularly you, Jonathan, given your involvement in the EMA case.
Oh, stop it. Go on, then. What's the issue?
Okay, here's the basic problem. A tenant break clause in a lease provides that, as a condition of the break being effective, the tenant needs to give vacant possession on the break date. Perfectly common clause. Or, as an alternative, the clause might provide that the tenant needs to have complied with its repairing obligations.
Yeah.
Now, because of the restrictions surrounding COVID-19, the tenant isn't able to satisfy those conditions. For example, the premises have got stock in them, or there are some dilapidations which need to be remedied. So, does that mean that the tenant can't break at all? Or is there a way that the tenant can argue that the conditions should somehow be ignored?
Yeah, I know. I mean, I've had exactly these sorts of issues as well. I think anything wider, anything where you've got a deadline coming up at the moment is going to be really difficult. But I mean, the first question is always going to be why can't the tenant comply? And the actual legal restrictions are in the health protection coronavirus restrictions England regs 2020, and there's a Welsh version. That's put us in a rolling 21-day emergency period when the restrictions apply. That's what the government's revisiting today. Reg 4 shuts down certain businesses and premises, restaurants and cafes, that kind of thing. It says they have to close, but they can continue for consumption off the premises. Other businesses like theatres or broadcasts must cease carrying on businesses, but like restaurants can supply that outside the premises. So on the strict wording of the regs, that could be read as a total shutdown, but I read it as shutting down the services being provided and particularly keeping the public out rather than stopping entry for the purposes of those associated with the business. Reg 5, which requires most shops to cease in-person sales and things like that, is similar, but that's sort of a bit more complicated.
And what people have been saying to me is that Reg 6 is the real practical issue here, because that's the one that's keeping us all at home. And we all know there's an exception to leave for works purposes, and your repairmen, your removal men, on the face of things, they might come within that exception. But at a practical level, employers just aren't sending people out to do the work.
Yeah.
Okay. So standing back at present, and of course this can all change overnight, but at present, you don't think the regulations themselves necessarily make satisfying the break clause conditions legally impossible, but it's just going to be a lot harder, or even possibly practically impossible.
Yeah, I mean, I think there's another layer to that as well, which is what about it being illegal or impossible to comply because it puts the people carrying out the repairs or the cleaning or whatever at risk? Does the employer or the contractor have either a tortious duty of care they'd be in breach of, or some kind of statutory health and safety obligation where they would actually be breaching the law by requiring them to perform?
But again, just at a practical level, it doesn't really matter in practical terms what the right answer to that question is, because if there's a risk, employers aren't going to send their employees out to do the work at the moment.
Yeah, I mean, when you get into talking about practical impossibility rather than illegality, you do start thinking a bit about frustration where performance is radically different to that envisaged. I know Joanne and Jonathan did a video on this earlier this week, but the short point is an increase in practical difficulty isn't normally enough. If you think of the Suez Canal cases, going via South Africa rather than through the canal wasn't enough. In Davis and Fareham, a labour shortage wasn't enough. If there's a labour shortage here, you can't find movers. Why does the reason for that shortage matter if it's not frustrating of itself?
Well, does that mean then that we get into questions of construction of the condition? Because I suppose if you've got a friendlier break clause, if you like, one that requires material compliance or reasonable compliance, then life for a tenant might be a bit easier.
Yeah, absolutely. I mean, just standing back for a second, we all know that conditions in break clauses need to be adhered to strictly. Yeah. Even the most trifling of failures, even the most trifling of disrepair, for example, will invalidate the break notice. But I often find one point that it's really easy to lose sight of is that while you have to comply strictly with the conditions, first you have to construe the clause to see what it is you have to comply strictly with in the first place. What is actually required?
Yeah.
That's a matter of construction, and there's no doctrine of strict construction when you're doing that process. And on construction, I mean, in addition to your point, James, I was wondering whether there was an analogy with Crass-Nicholson. In simple terms, in that case, a restrictive covenant prohibited development without the consent of a particular named company. And that company was later dissolved, meaning that it was impossible for that company to consent. Now, Justice Neuberger held that instead of the restrictive covenant becoming absolute, so that no development at all could take place, the restrictive covenant was discharged entirely. So if we get to a point where compliance with the conditions in the break clause is impossible because of regulations, might it be said that the condition is, as a matter of construction, discharged in that same way?
Yeah, I mean, there's the whole other layer as well, isn't there, when you're construing a term, which is you've got to look at the rest of the lease, the rest of the contract. Now, if you think about the standard covenant requiring the parties not to use the premises, or the tenant not to use the premises illegally or immorally, what happens if performing the relevant condition for the break, such as repairs or cleaning out, would be an illegal user because it's either directly in breach of the coronavirus regs or it's a breach of health and safety law? You know, we know elsewhere in landlord and tenant repairing / quiet enjoyment context that you try to make the clauses work together, but it's very difficult, I think, to make that work together if it would be a breach of the lease to comply with the condition. How does that work?
Well, I've been wondering about implication as well, because there's sort of something quite attractive about saying that it must be so obvious as to go without saying that the parties won't insist on compliance with conditions when it becomes practically impossible to do so. And that at first sounds quite attractive. But the more you think about it, the more tricky I think it becomes. Because at the time that you enter into the lease, which is the relevant time for implication, there are all sorts of reasons why performance might in due course become impossible. And it's difficult to see that the parties could have intended a release in all of them. And also, it strikes me that there's scope for loads of argument about what the real reason for non-compliance actually is. Because you can just see that a landlord is going to say, well, you could have complied before lockdown, you had a chance, you missed it. Or the landlord's going to say, well, by lockdown, it was too late. You'd missed the boat. You were never going to comply anyway. And that, it seems to me, kind of feeds into implication, because when parties agree strict terms for a break clause, it's precisely to avoid that kind of factual argument. So it's kind of anathema to what they're doing with the clause.
Yeah, I mean, that point makes me think a little about force majeure clauses, because in those cases, you have to think about whether a party could have taken reasonable steps to avoid or to mitigate the supervening event or its consequences.
Yeah, and then of course you say force majeure and you drop right back onto, well, are we actually back in the realms of frustration again? Yeah. I mean, the trouble is we don't have a doctrine of partial frustration. So what we do have is supervening illegality. That is where performance has become illegal as a result of a change in the law after the contract was entered into, which turned up in ENA. But I mean, at first glance, it seems quite a stretch to say that because it's illegal for the tenant to satisfy one condition in one of the clauses, the entire lease should go. But I mean, I was wondering if you could say break clauses are special. Could the tenant say, I agreed to a lease that I'd have an opportunity to break in spring 2020. The law has changed, so now I'm prevented from doing that and locked in for another 5 years with no choice at all. That is actually radically different.
Oh, well, I mean, correct me if I'm wrong, but the impression I'm getting is this is just not straightforward at all. I mean,
I think that's true.
I suppose the first important thing to do is to consider whether compliance with the condition is legally impossible, as opposed to practically very difficult. That might make a big difference. And if it does become legally impossible, or perhaps even if it isn't, there are quite a few legal principles that we're all going to have to think about hard. Well, James, Jonathan, thanks for that. A real difficult issue. And meanwhile, I hope you both keep safe and well.
Yeah, thanks, Ben. Cheers, you too.
Stay safe.